So this is just We the People News. Alrighty. So this video is without prejudice and or without recourse. Okay? I'm not waiving any of my rights, none whatsoever. Alrighty. I'm not an attorney, so everything I say or do is just my opinion. My opinion only, people. Alright? I'm do not practice law. Okay? I tried to get it right the first time. But, let's try to reevaluate our Ninth Amendment. And I guess I accidentally came across this video, and they could probably explain this better than I can. There ain't no probably. I'm not a genius at these things. I know they can explain this better than me. Alright, so let's have a relook, a revamp on our Ninth Amendment, and we need to actually start standing. And I say our Ninth Amendment, it's not ours. It's the government. They can't trespass upon our rights. Okay? And this Ninth Amendment is actually being trampled on what little they actually used it, because they don't like people using this. Alright? Because it gives too much power to the people. And they've been trampling and kidnapping people's inalienable rights. Okay? And I think we need to start working on how to get our Ninth Amendment in the paperwork and the 10th Amendment. Okay? The 10th Amendment says at the very end, reserved to the states, or, let's go with this key part, or the people, y'all. Okay? It's time to stand on the 10th Amendment. So you add the 10th, 9th, and 10th Amendment together, that's a very powerful thing. Okay? So, it's going to be kind of hard for the courts to accept such thing, because, I mean, geez, heaven forbid if the sheep gets outside the pen, you know, they're going to lose their kingship, you know, and these judges going to realize, you know, the people are actually the kings, and they're their sheep. They can't have that, but the people need to, you know, while that gate's open, needs to step outside the gate and find out what's out there. Okay? And quit banking all these attorneys that literally are on the judge. They can't out make enemy of the judge when they operate and see the judge every single day. You know, that'd be basically kind of stupid on their part. But that's what you pay them for, is to be against that judge.
From the very beginning, the whole point of the Ninth Amendment was to prevent the Bill of Rights from being a ceiling on the rights we have against the government. It's simply a floor.
Essentially, it's a hold harmless provision for unenumerated rights. It doesn't elevate them into constitutional rights, but it leaves them exactly as they were before.
The Ninth Amendment is the most important sentence in the whole Constitution.
The enumeration in the Constitution of certain rights
Shall not be construed to deny or disparage
Others retained by the people. The Federalists, who wanted the Constitution ratified without a Bill of Rights, argued or warned that adding an enumeration of rights would be dangerous, because it might suggest that the only rights that people had were the ones enumerated, and that the people had surrendered up to the general government any rights that had not been enumerated.
And Madison came up with a brilliant solution. He said, well, why don't we just have a rule of construction that says the enumeration of certain rights in the Constitution, for example, in the Bill of Rights, shall not be construed to deny or disparage the existence of others. Very clever. That's what the Ninth Amendment said, and that's its origin. So the original meaning of the Ninth Amendment, in my view, the current meaning as well, is simply that the...
Let's go with not meaning, but the original intent. Okay? Inequity. Okay? Intent. Not meaning, intent.
Constitution is not a finite list of rights. It's more open-ended than that.
Now, the question that the Ninth Amendment raises is what is the legal status of the unenumerated rights, the ones that haven't been listed in the Bill of Rights or elsewhere.
You first of all have to understand
But we had to still reevaluate on that. What is the lawful intent?
the meaning of the phrase rights retained by the people. A retained right is a natural right. That is a right that people have before they form government and then they retain after they form government.
It means that these are rights that pre-existed the Ninth Amendment. They're not created by...
Whether you believe in religion or not. Okay, the Creator said that I give you dominion over the land, the air, and the water. And when you take the first three letters there, that says law. So the number one law is the Creator. And everything has to revolve around that.
the Ninth Amendment.
Those rights are simply the liberty to do what you will with what rightfully belongs to you.
There is no formula. And that, of course, leads some people to say, oh, well, if there is no formula to tell you for sure what the unenumerated rights are, they must not exist. But that doesn't follow. There's no formula to tell you exactly what rights you have under the freedom of speech either.
The evidence is pretty powerful that natural rights were treated as
But even then, they actually put a restriction on that, y'all. Because they're grabbing power.
authoritative up until the point when they were displaced by a specific, explicit, intentional, positive law. A positive law is an enacted law by the sovereign, as opposed to, say, a natural law or a law which has its force from long-standing custom.
For the first 150 years of this country, all the rights retained by the people, both enumerated and unenumerated, were largely protected by holding state legislatures to a proper conception of their powers. All the focus was on powers, not on rights. Going into the 20th century, a big change happened because political progressives started urging the court to engage in what we now call judicial restraint and what was then called judicial self-restraint, in which they defer.
And I had to beg the difference. I think it's attorneys, y'all, that's doing this. Okay? All the headaches and the rights we've been losing has actually been by attorneys since the bar came out. Piece by piece.
To Congress or to state legislatures by adopting a presumption of constitutionality, and in some cases an irrebuttable presumption of constitutionality.
Until the 1930s, roughly speaking, the Supreme Court was much more sympathetic to the claims of liberty. As long as you were an adult male and not a kid and not a woman, it should be up to you, not up to the government.
After the New Deal, and especially into the Warren Court, the justices started to pay very little attention to the text of the Constitution. The idea here was let Congress and let state legislatures regulate economic activity however they wish, and then we may put some restrictions on their ability to regulate what we might today call personal liberties.
Yeah.
The need to focus on the Ninth Amendment begins with the 1938 case of U.S. versus Caroline Products. In that case, the court, in a very famous footnote, footnote 4, said, you only get heightened scrutiny if it's an enumerated right.
Caroline Products footnote simply announces that the court will give a broad construction to power granting provisions of the Constitution, and it will also enforce enumerated rights, but that it will neither give a limiting construction to the powers granted, nor will it enforce unenumerated rights. I don't think that contradicts the Ninth Amendment at all. Remember that the Ninth Amendment simply leaves unenumerated rights as they were before. It does not elevate them into constitutional rights.
In the body of Caroline Products, it says that somebody may still challenge a restriction on liberty as not being within the proper powers of the legislature to enact. But that gets essentially reversed by Williamson v. Lee Optical in 1955.
Williamson versus Lee Optical is an extreme case because it's a law which is obviously just a bit of special interest legislation and probably the product of corruption.
Williamson v. Lee Optical marks the end of the court's willingness to protect the unenumerated rights retained by the people that the Ninth Amendment is there to safeguard. The case stands for the proposition that unless you have an enumerated right, you get no protection at all. The legislation will simply be upheld as rational. This is what's come to be known as the rational basis test, which, if you take Williamson literally, means the conceivable basis test, because the judges will uphold any law that they can conceive has a rational basis, even if that's not the reason why the law was passed.
But this
Aren't they doing that, y'all? Look at the family courts.
Supreme Court, I think, correctly held that the Equal Protection Clause was not designed to protect us from the follies of our legislature when it decides the domain of legislation. If the Equal Protection Clause empowered courts to second-guess the domain of every enacted law, effectively it would turn the courts into a super legislature, taking over the job for which we have elected our representatives.
The question of which rights are
Yep. Aren't they doing that now?
included in liberty and which are not, of how much deference there should be to the state when it regulates liberty in the interest of equalizing bargaining power. Those are hard questions, but they have nothing to do with the rule of construction in the Ninth Amendment.
Interest in the Ninth Amendment grew in the last several decades when the Supreme Court started giving heightened scrutiny to laws that intruded upon one of the enumerated rights and limited the protection only to the enumerated rights, which seemed to implicate the Ninth Amendment's warning or admonition that the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people.
Griswold versus Connecticut, the contraceptive case, may be as close as we've come to the Supreme Court recognizing the Ninth Amendment as an independent source of legal authority.
Griswold versus Connecticut involves a restriction on the sale and distribution of contraceptive devices to married couples. A majority of the Supreme Court invalidated the law in Griswold, invoking what's now called substantive due process to protect an unenumerated right of privacy. One of the justices, Justice Goldberg, in a concurring opinion said, this is warranted by the Ninth Amendment because the Ninth Amendment acknowledges the fact that the enumeration in the Constitution of certain rights does not preclude the protection of an unenumerated right like a right of privacy.
In effect, he used the Ninth Amendment for the first time in the way that it was intended to be used, as a rule of construction, as a way of saying, in our kind of society, something that is a fundamental right can't be denied just because you can't point to chapter and verse in the Constitution that lists it.
It rejected the idea that only enumerated rights get protected. But on the other hand, it did not revive the original way of protecting unenumerated rights by saying that all legislative restrictions on liberty need to be scrutinized to see if they are rationally related to an end that is within the proper scope of government.
Goldberg seems pretty careful in his opinion to deny that the rights actually come from the Ninth Amendment.
But unfortunately, that was just a solo opinion by Justice Goldberg. The Richmond newspaper's case in 1980, which coincidentally is the first case I ever argued in the Supreme Court, is the first case in which a plurality opinion of the Supreme Court relied on the Ninth Amendment to establish the existence of a fundamental right. In that case, the fundamental right was the right of the public and the press to observe criminal trials in the absence of some extraordinary need to exclude the public from some part of the trial. And Chief Justice Burger, writing a plurality opinion, he invoked the First Amendment He said the First Amendment might not quite suffice, but then he dropped a footnote that said the history of the Ninth Amendment shows, as Madison explained to the Congress, that the fact that the right in question, the right of the press and the public to observe a trial that the parties don't want anyone to observe, the fact that that is not explicitly protected doesn't prevent it from being a basic right.
You can look to the case of Troxel versus Granville, decided in 2000. A local family court had ordered visitation rights over the mother's objection, and the Supreme Court reversed that and argued that the mother had a right to raise her own children the way she saw fit. The right to raise your children as you see fit is nowhere enumerated in the text of the Bill of Rights. If you limit the protection of constitutional rights only to the rights that are enumerated in the text of the Constitution, then the state can take your children away from you. It's hard to imagine a right that's more fundamental.
Aren't they doing that, y'all? What do you call CPS?
Than the right to raise your children as you see fit. And yet, that's an unenumerated right that happily the Supreme Court protected in Troxel versus Granville. Justice Scalia dissented. Why? Because he said, although the right to raise one's child as you see fit was one of the rights retained by the people that the Ninth Amendment protected, he argued that it was not up to judges to decide what those rights were and then protect them.
Scalia refused to.
Yeah. Kind of like father's rights. Or, or mother's rights just depends on the non-custodial crap they use. Right? 50-50s. That's what it should be. Period. And if the mom or the dad, just depends on what side of the aisle you're on, wants to sign a contract and get food stamps, Medicaid, and all that, the other half does not have to pay for that. They didn't sign the contract to agree to them terms.
Countenance and interpretation of the Ninth Amendment protecting that right because of the dangers of empowering unelected courts to be able to basically make up the content of rights.
Under Justice Scalia's approach, the only way that an unenumerated right gets protected is if the legislature decides to protect it. But of course, we don't treat any of the enumerated rights that way. We say the legislature must respect an enumerated right, and judges will make them respect an enumerated right.
The danger is that we now have a...
And once again, giving more power to the government. They've been stealing people's inalienable rights. And don't forget, our founding father says if it's unconstitutional, it's null and void. We need to start challenging this. Wait a minute, you guys are going by this case, but it's null and void. It's unconstitutional.
A 9-person legislature that has final word on everything, and they serve for life. And as for me, I'd rather live in a republic.
In a democracy, giving the final word to any institution is always problematic. But if there is to be a rule of law, somebody has to have, at least temporarily, the last word. Justice Jackson famously said, "We are not final because we are infallible. We are deemed infallible because we're final." The Ninth Amendment is beautifully written. I just wish it would be beautifully read.
And it's not final. It's called an opinion. That's what it's supposed to be. Supreme Court is a opinion. It's up to the people in the states to say, hey, wait a minute. These judges said this is unconstitutional, so we're not keeping this law. But the judge, or the Ninth Circuit old farts up there, don't really have the final say. We just been dumbed down saying they had the final say. They keep on calling it a ruling. It's not a ruling. It's a fucking opinion.
As a matter of practical litigation reality, the Ninth Amendment is virtually a dead letter. No majority opinion in the history of the Supreme Court has ever invalidated invalidated a law, federal or state, on the basis of the Ninth Amendment. I do not think that the Ninth Amendment deserves a lot more attention in court. But I do think something that the Ninth Amendment points us to something that may have been forgotten that might be good to revive. And that is, again, you ask, what is the status of natural rights that existed before the Bill of Rights? I do not think they were eliminated by the passage of the Bill of Rights. That's what the Ninth Amendment tells us.
The problem with today's jurisprudence is that it really creates two boxes of rights: the enumerated rights that get heightened scrutiny and the unenumerated rights that either don't get heightened scrutiny, or if they do, people criticize that for being illegitimate.
American jurisprudence was also by lawyers, y'all.
Ninth Amendment, if properly understood and fully protected, would probably constrict government in a number of respects, precisely because, in a way, the power of government is the flip side of the coin. That is, the government's power can be defined only after you take away from that power the rights that people have against the government. And if those rights grow, as they would under the Ninth Amendment, the residual powers of the government would correspondingly recede.
A heightened protection of economic liberty is probably the biggest change that would result from judges enforcing the original meaning of the Ninth Amendment.
You know, there's an infinite number of rights that we exercise all the time that are not listed in the Bill of Rights. And if the legislature exercising one of its enumerated powers cuts into those, by and large, the legislature is within its rights if it's exercising an enumerated power.
Maybe the most important thing to keep in mind when struggling with the Ninth Amendment is distinguishing between the meaning of the text, what is the original meaning of the text of the Ninth Amendment, and the issue of judicial role. What should judges do about that text? Those are two...
Again, not meaning, intent. What was the founding's intent when they wanted to keep government out of our hairs?
Questions. We can agree about each and every word in the Ninth Amendment and what it means, and still disagree about what judges ought to do about that.
Anyway, there you guys go. Something to think about. Kudoki. I don't have really any more to say about that. Never, never, never look just straight forward. Always look around you to be able to protect yourself by any means necessary. Till next time, peace with the People News. Bye, y'all.